things that motivated them to put this free exercise and establishment clause in the Constitution. Let's go ahead and say that the government can run a church, because that's not a big deal. It's not a problem anymore. That's concerning. I think that's really concerning. So let me just take an issue with a few points that I think are really important. This idea that somehow you would look back and say, well, what were the concerns that motivated the inclusion of the Second Amendment in 1791 to the document, when the relevant provision is the 14th Amendment that was added in 1868, is something you really need to think about, because the set of concerns were different. I mean, the people who wrote the document in 1791 had just thrown off British tyranny and created this experimental new government. They had a much different set of concerns than the people who wrote the 14th Amendment, who had just fought a civil war to liberate a class of people and then turn around and found those people effectively still enslaved and being essentially predated and terrorized and lynched, because they had, in part because they had been disarmed and made vulnerable to that conduct. Those two sets of concerns are completely different. And to act as if the set of concerns that motivated the framers of the original Constitution in 1791 can just translate jot for jot to 1868 when they added the 14th Amendment is just not real constitutional law. It's not how we do it. And it would lead to all kinds of bizarre results if we did that with respect to other provisions of the Constitution. My goodness, I mean, the Eighth Amendment, the cruel and unusual provision of the Eighth Amendment, they were branding people and notching their ears back in the late 18th century. Does that mean it's okay now? No, we've evolved since then. And, values have changed. Constitutional principles don't change, but our application of those principles can change over time. The question just becomes, how do you approach the Constitution in an appropriately consistent way? And, for those of us who go to bat or who think of the 14th Amendment as providing a fairly broad array of liberties, and I absolutely do, both enumerated and unenumerated. I'm not saying you don't look to the Bill of Rights to help form your view of the 14th Amendment, but the idea that you sort of focus on it with laser-like, dogged precision is just not the way we do things. For example, there's nothing in the Bill of Rights about your ability to travel. Nothing. And yet, the 14th Amendment does protect your ability to travel. At least the Supreme Court has held that it does. And quite right, too, because that was another thing that was going on in the South. They were essentially, in order effectively to keep people in a state of constructive servitude and have them continue to work at your plantation, you have to prevent them from leaving. And newly freed, African Americans were leaving. They were trying to. They didn't want to work on those plantations anymore. They wanted to go to Chicago or New York and get better paying jobs. So there were all kinds of laws at the time. There were even laws that said that you couldn't be found off of, well, if you're black, you couldn't be found off of your employer's property without a note from your employer. You don't have to be a rocket scientist to figure that out. That's to keep you trapped on that plantation. So even though there's nothing in the Bill of Rights about being able to travel around, and there's nothing specific in the 14th Amendment that says you have a right to travel, it has been interpreted that way. Why? Because that is consistent with the relevant history. They were trying to trap these people so they could continue to exploit their labor after the Civil War and prevent them from leaving in search of better opportunities, and the 14th Amendment was designed in part to prevent that. And the other rights you could go on forever. I mean, unfortunately, I wish you could. But there are other rights. The right to raise your own children. That's protected by the 14th Amendment, according to the U.S. Supreme Court. I totally agree with that. It takes a bit of historical extrapolation to get that from the history of the 14th Amendment, but probably most of you know that one of the features of slavery was the slave masters would dictate who you could get married to, who you could procreate with, and they would break up families and send them all over the place. And so I don't think it's too much of an extrapolation to say that the 14th Amendment, in attempting to end Southern tyranny, may have had as part of its motivation, or at least within its ambit, the idea that the government is not allowed to break up families or has to respect the family bond. I think that's a perfectly legitimate decision. But we don't look back with slavish focus to the 18th century when the Bill of Rights was added to the Constitution. They were concerned about totally different things at that time. And it ignores the history. This whole states' rights thing, it grates on me. The whole period leading up to the Civil War and the years after the Civil War were a kind of a national realization that states' rights is a horrible concept. States don't have rights, they have powers. And they weren't exercising those powers responsibly. there was a kind of a fantasy or a myth early on in the Republic, that states were small and closer to the people, and this would make them more protective of liberty. Well, we found out in a big way, leading up to slavery, or the Civil War, and afterwards, in terms of how the southern states, they violated all kinds of rights to keep slavery in place, including silencing people who wanted to talk about abolition. So we learned in a big way, states, far from being the guardians of liberty, were among the primary violators of liberty. So we don't look, that's the basic point, I guess, if I had to sum it up. We don't look back to the time when the Bill of Rights was added to the Constitution in any other setting that I'm aware of when we're talking about whether a particular right is protected by the 14th Amendment. Why in the world would we do it just for the right to keep and bear arms? It's so exceptional, it's so odd. And again, it's just an inconsistency that is done in order so you can come to a particular result. I don't want to see the purpose of the framers of the 14th Amendment to enable people to own guns translated in modern times. So I'm just going to do constitutional law different than I would in any other setting. I think that's wrong. As you probably know, or maybe you don't, the Supreme Court, in its initial interpretations of the 14th Amendment, acted as if it didn't mean anything, effectively. Basically, in the slaughterhouse cases that came up 5 years after the 14th Amendment was added to the Constitution, basically a 5-justice majority said, well, this idea of shifting power from the states to the federal government and empowering federal judges to protect individual liberties is an improvident shift in power, a bad idea. So we're not going to interpret the 14th Amendment as if it did that. And instead they said the 14th Amendment protects a set of relatively trivial rights, like the right to access navigable seaports of the United States and to call for the protection of the federal government when on the high seas. Ridiculous, ridiculous interpretation of 14th. We did not fight the Civil War over access to seaports. We didn't. The inability of freedmen to have access to seaports and to be able to call on the protection of the federal government on the high seas was not what prompted the 14th Amendment to be added to the Constitution. It was the systematic, widespread, and relentless violation of every civil right that they had. Not just freedmen, but also their white supporters. That's what prompted the 14th Amendment to be added to the Constitution, and that's how you have to interpret it if you're going to do constitutional law consistently. At least that's my view. So I'll summarize by saying this. I am not here to tell you, and by the way, I take this idea that I don't approach different parts of the Constitution differently. That's incumbent on me too. So, for example, the First Amendment, free speech provision, has all kinds of limitations on your ability to speak for them, more than I would like to see. Time, place, and manner restrictions. Commercial speech is held to a lower standard than non-commercial speech. So there's all kinds of restrictions on your ability to exercise your First Amendment right of free speech. And I'm okay, just to be clear, with there being also restrictions on your ability to exercise your right to keep and bear arms. I don't think, by the way, that it could be limited to just having a gun in your home for self-defense. That would not have done you very much good in the Reconstruction era South. That gives you a right to just cower in your home with a gun when the Klan's riding around outside? No, you should be able to go down to the store or your mailbox or whatever they had back then. And you're going to need to take your gun with you if you're a well-known, resistor to Southern tyranny. And so I reject the idea that Justice Stevens had that we feel it's just about having a gun in the home for self-defense. No, not so. Wouldn't have done the kind of good that they were trying to do back then. So I think you have to be consistent. I'm willing to be consistent. I'm willing to say there can be time, place, and manner restrictions on your ability to own a gun, just like there are on your ability to speak. But I'm also going to say that the government needs to be able to come in and make a really compelling case that this restriction on your ability to own a gun is necessary to advance some really important public purpose. I might even go less than strict scrutiny. Usually free speech restrictions are subject to strict scrutiny. I might be able to live with something closer to intermediate. But what I would say is that in order for the right to keep and bear arms to mean something, and specifically to mean what it seems to have meant to the people who added the 14th Amendment to our Constitution, the government needs to take the right seriously, and it needs to understand that you have a right to own a gun, and as long as you exercise that right responsibly, as in any other constitutional setting. And if it can't show that you personally have abused that right or are very likely to abuse that right, then it needs to respect it. And I think whether the courts are actually going to enforce that purpose that I think is embodied in the 14th Amendment, and that I'm absolutely convinced that the history of the 14th Amendment I've shared with you supports, remains an open question, but it'll be certainly interesting to watch. Thanks.
Thank you very much. We will now go to our rebuttal period. in the interest of time, because we want to have a little bit more time for question and answer period, we're going to have 5-minute rebuttal for each participant.
I don't have much to say. This debate seems to have evolved into unanimity. As I said before, I would be happy to accept a right to bear arms in the home for self-defense under the Privileges and Immunities Clause. I said I generally agreed with Justice Thomas's concurrence. But that's not what the majority in McDonald said. McDonald said it was part of the Second Amendment, right to bear arms was incorporated into the 14th Amendment. And while my friend here doesn't seem to think it mattered what the framers of the original Second Amendment meant, Justice Scalia and his colleagues certainly thought it did. He said it meant the right to overthrow the government. But my colleague doesn't comment on it. He wants a privilege. Well, he says he wants a privilege to be a little stronger than just to keep it in the home. I would start with the privilege and immunity of a right to keep a weapon for self-defense in the home, and let the states decide how much further they could go. So there's not a lot of difference between us, except that's not what the Supreme Court ruled in McDonald. And I take it we both agree that the Scalia opinion was wrong in McDonald. That's what I take from his comments. But I want to make another comment about the protection of the freedmen in the South after the Civil War. The right to bear arms to the newly freed men, a lot of good, didn't it? Really helped them. The only people it helped was the Ku Klux Klan. It was up to the federal government to stop the Ku Klux Klan. It was up to the federal government to take the guns away from these marauders in the South. But what did the federal government do? What did the politicians do? Anybody ever heard of the Compromise of 1876, the Hayes-Tilden Compromise? Letting the Republican Hayes become president in exchange for removing all the federal troops from the South, thus ending Reconstruction and leaving the newly freed slaves and their allies at the mercy of the armed minions of the Ku Klux Klan. That's what the right to bear arms brought about at the end of the Civil War. So this notion that somehow or other this was a protection for freedmen in the South is sheer nonsense. Fantasy. Never happened.
If you were in the KKK in 1870, you didn't need a right to keep your arms. You were the government. Or you lived next door. They didn't need a constitutional right to keep and bear arms. They were the power structure. The idea that they needed a right to be able to go to federal court and say, hey, you know, I was on my way to a lynching tonight, and I feel like I want to take a gun with me, but they said I couldn't, so do I have a right to do that? That's a fantasy. These guys were the power structure. They weren't up against any laws that were trying to disarm them. They didn't need any amendment to protect their ability to have a gun. The problem with the 14th Amendment, as I thought I made clear, I tried to make clear, is not in its aspirations, not in its text, not in its purposes. It's in the fact that the Supreme Court repudiated it, strangled it in the cradle in 1873. That's why it didn't work out so well for freedmen or their white supporters in the South. That's why they continued to be systematically disarmed, is because the Supreme Court led the way and said, oh yeah, that amendment you just added to protect all these rights, screw you. That was the problem. Not the text of the amendment, not the purpose of the amendment. In fact, to the contrary, had the 14th Amendment been faithfully enforced by the courts during the period of Reconstruction and afterwards, I think the history would have looked much different. I don't know what it would have looked like, but much different. Imagine how it would have been if a freedman or a white abolitionist could have gone into court and said, geez, you know, these guys showed up, this Southern militia showed up and disarmed me last night. I'm afraid they're going to come back tonight and lynch me. And if you could get an injunction from a federal judge saying, give him back his guns or her guns, might have looked a lot different. I don't know. But that's what they were getting at. That's what they were trying to do. And the Supreme Court bailed out on that. And then shortly after, I agree, the rest of the nation did too. And as I said before, it was disgraceful. It was the second worst stain on this country's history after slavery. It was a disgraceful, disgraceful era. But it was a disgraceful era precisely because of the failure of the nation to protect the rights of newly freed slaves and their white supporters. against these kind of depredations. So the people who proposed and ratified the 14th Amendment, they were heroes. They got it right. They were trying to do the right thing in my view. But it was everybody else who copped out.